Hello, respected viewers. I'm George from Ireland. So I'm continuing about human rights in the United Kingdom. It's a huge topic, but about the Human Rights Act, and particularly the interpretive obligation, because under Section 3 of the said Act, the courts must, in as much as possible, interpret UK legislation, both primary and secondary, in a manner that is consistent with the European Convention of Human Rights. Sometimes it's not possible. So Section 3 of the HRA says the following. So far as it's possible to do so, primary legislation must be read and given effect in a way which is compatible with convention rights. This section applies to primary legislation and subordinate legislation whenever enacted, but does not affect the validity, continuing operation or enforcement of the incompatible primary legislation. Does not affect the validity, continuing operation of primary or enforcement of incompatible subordinate legislation if, disregarding any possibility of revocation, the primary legislation prevents removal of the incompatibility. So, supposing the court sees some UK legislation and tries to interpret in a way which is consonant with the European Convention of Human Rights, but they can't. Well, what does the court do about it? They report it, they make a declaration of incompatibility, they don't strike down that piece of legislation, they have no legal power to do so, whereas in some countries they would. What is the way that the UK courts function? It's rather different from, say, the US Supreme Court, for instance, Supreme Courts in Republic of Ireland, Germany, France, and so forth. There are other countries that call them constitutional courts, which are empowered to nullify legislation if they found it is repugnant to the Constitution. Professor Bogdanor, in this time, he said that the government came up with a novel method in the Human Rights Act to try to strike a balance between parliamentary sovereignty and upholding human rights. So if the statute has two or more interpretations, the court has to choose the one which is consistent with convention rights, as in the rights you find in the European Convention of Human Rights. It could be that there aren't two different interpretations, they just have to go with the one which is inconsistent with the European Convention of Human Rights. So the courts are entitled, according to Section 3 of the Human Rights Act, to be creative in their exegesis of legislation. They can't adopt a meaning which really flies in the face of the core purpose for a piece of legislation. So courts will interpret these things broadly where they can. There was a case R&A before the UK House of Lords in 2001, and Lord Steen said this: in accordance with the will of Parliament, as reflected in Section 3, it will sometimes be necessary to adopt an interpretation which will linguistically appear strained. The technique to be used will not only involve the reading of express language in the statute, but also the implication of the provisions. So they will infer from the legislation what they should be doing, or what the purpose of this was. So in the case I cited, the law lords, they had to decide whether Section 41 of the Youth Justice and Criminal Evidence Act 1999, which said that evidence and cross-examination about past sexual conduct of a complainant wouldn't be allowed unless there was extraordinary permission from the court. So the court in this case decided, the House of Lords in this case decided that they would permit evidence to be introduced about previous sexual behaviour between a defendant and a complainant, because they thought they needed to do so in order to guarantee the defendant a fair trial. Remember, under Article 6 of the European Convention on Human Rights, everyone is entitled to a fair trial. So the court said that they would just assume those words to be there, and in that wise they could interpret the Youth Justice and Criminal Evidence Act in a manner that was consistent with the ECHR. Because generally speaking, if someone says, I've been raped or sexually abused or whatever, you're not allowed to say, yes, but you would have voluntarily liaison with this person beforehand. That's seen not to be a valid argument. Should it be a valid argument? That's another debate. All right. Another important case on this issue was Gaiden and Godin Mendoza, a 2004 case. Again, went all the way to the UK House of Lords. And this is another textbook case where the judges had to be somewhat creative, using a rather innovative interpretation as provided for by Section 3 of the Human Rights Act. The House of Lords was looking back to the Rent Act of 1977, which mentions a spouse. So what is a spouse? Someone who lived as a husband or wife. Could this apply to same-sex couples? And the House of Lords decided that it could. Whereas in 1977, that wouldn't have been the case. But times had changed, and by 2001, gay civil partnerships were not far off. So they have to try and interpret things in the light of the social reality. So this meant that the Rent Act was compatible with Sections 8 and 14 of the ECHR. So Lord Steen said the following in relation to the said case. Nowhere in our legal system is a literalistic approach more inappropriate than when considering whether a breach of a convention right may be removed by an interpretation under Section 3. Section 3 requires a broad approach concentrating, among other things, in a purposive way on the importance of the fundamental right involved. So purposive as in with a purpose, like purposeful. So in this case, it allowed the defendant in that case to take over his boyfriend's statutory tenancy as a sitting tenant, because otherwise say, well, the guy's died, you can't get it, you were his living boyfriend for years, so what? You're not a spouse. But the House of Lords said, in effect, he is a spouse. So, the law is not absolutely rigid, it's a little bit flexible. It can adapt for a new situation. So the House of Lords here was breaching convention, was going against precedent. There was Fitzpatrick and Sterling Housing Association in 2001, where the appellate court had come to the opposite decision. But obviously the House of Lords having made its ruling, the House of Lords is authoritative, and the lower courts shall be bound by that precedent. Okay, under Section 4 of the Human Rights Act, this is where the court can make a declaration of incompatibility. So if the courts can't interpret legislation in a manner consonant with the ECHR, the court will issue this. I mean, only the High Court, the House of Lords, the appellate court could do so, not magistrates' courts or county courts, because they're too low in the tiers. Tiers as in not like lacrimating, but levels, that is. Like it comes from un tiers in French, a third, although there are more than 3 levels, 4 really. So the courts, they usually regard issuing declaration of incompatibility as a last resort. So Lord Steen said this again in Gaiden and Godin Mendoza. He said, if the court is satisfied with the legislation said, if the court is satisfied with the provision is incompatible with the convention right, it may make a declaration of incompatibility.